Pat and I are back for a wonderful encounter with a legal expert on this most recent Supreme Court decisions.
Bet your bottom dollar that Shively Shoulders will penetrate to the heart of every issue. There will be no fence sitting today on Shively Shoulders.
All right, Pat, a little quiz for you. Who am I?
Easy Rider.
I'm the big guy.
Okay. Now, it is altogether fitting and proper that you might have those sunglasses on, representing our President, Joseph Biden, who attempted to bring debt relief to many students across the United States. But before we get to those issues...
What got in the way was the Constitution. We'll talk about that a little later.
What got in the way was an ideologically driven Supreme Court, which is what we're going to talk about with our great guest we have today. But before we get there,
yes, sir,
let us banter. We've been assigned things like global warming, which your old party didn't believe had anything to do with human conduct.
Well, I stand corrected. It's July and it's hot outside. Maybe they're right.
Vermont people, you didn't think you needed a boat? Enjoy while you're flooding your capital. We also have Curtis Hill, making his party proud, running for governor, I assume.
You know, there's a new definition of useless, meaningless efforts.
Yes.
Curtis Hill's candidacy falls in that. There may be a new Webster dictionary with his picture for that new definition.
Well, we've got a great string right now of Republican attorneys general. You go from Curtis Hill, who's disgraced and was abandoned by his party, to Todd Rokita, who embarrasses us weekly, daily, and monthly with the positions he takes on behalf of our great citizens.
What's interesting about Attorney General Rokita is that early on, it looked like he was going to run for governor.
Yep.
Now there's all these candidates in the Republican primary. He's not one of them.
I'm surprised our local prosecutor hasn't endorsed him already, but I digress.
Let us easy. You never know where you can get a ticket, man.
The Vanderburgh County, we had a headline this week in the paper that our public defender's office is overworked and overwrought. And you know, I was on the original board when Betty Lou Gerald worked very hard, and the theory was correct, that we should have full-time public defenders and not just judges throwing cases to the right and to the left. But, newsflash, the legislature takes on good ideas and never fully funds them.
That's not quite correct. They fund about 40 to 45% of each county, participating county's budget.
Right.
The real problem is the Defense Council, that means the Public Defenders Council, has set these unrealistic case ratios. The number of attorneys in that office could probably handle a few more cases, but if we go beyond that ratio, we lose our money. And we really need to sit down these folks, maybe members of the General Assembly, and get some realistic caps so we can get the utility out of the dollars that are there. I think that's what, behind the scenes, I think that's really what the problem is right now.
You would know more about that than I would. That's a limited number of topics, but I will concede that one. And finally, before we get to our great guest today, and we've got lots to talk about with the United States Supreme Court's missteps here in the closing of its terms, I want to hats off. I hope you did, the fireworks display. Again, a lovely celebration this community does on the 4th of July out over our river.
Well, I'm glad to hear that you participated, the rest of us Americans, on that. On the birth date of this country.
I'm happy to sing God Bless America if you would like me to take that time.
Well, maybe the end of the program.
Oh, okay. When we come back,
yes, sir,
we have none other than the president of the University of Evansville to discuss with us many cases that our Supreme Court has just handed down. You did not know that he's a former law school dean.
Of Stetson in Florida.
It's not just a hat. Stay tuned. Welcome back. We are honored today to discuss with us cases decided by the Supreme Court, someone who was a law professor at LSU, the dean of a law school at Stetson, and now president of our own University of Evansville. But first, we need to talk to Chris Pietruszkiewicz about the hole-in-one that he had last weekend at the Evansville Country Club.
I did, Pat, and we weren't even playing together.
We
I
were
think
not.
That's probably why it happened.
Was it on number 14?
It was on number 8.
Number 8, what club did you use?
Pitching wedge.
Pitching wedge and a hole-in-one. That should tell you, ladies and gentlemen, that this man's got it going. Welcome, Chris.
Good to be here.
Can
Thank
we
for
call
having me.
you, or should we call you President P? Is that what the students call you?
Pres P is what they call me on campus.
Pres-
And you can call me anything as long as you wear purple.
Pres P, that's so that you can handle his last name, Les.
Thank you, Patrick. Well, the Supreme Court ended its session on June 30th, and as typical, they wait to the last minute to hand down these rulings, and there were a bunch of them. And I think the most significant decision to come out of this court is Students for Fair Admissions versus President Fellows of Harvard and University of North Carolina, which, for all intents and purposes, there's a question of whether it truly eliminated affirmative action, but many claim that it did, and basically said that those two institutions using race as a factor in admissions was violative of the equal protection. Let me ask you this question, because I'm really confused on this. I thought back in 2003, forget the name of the decision, but I think
It's Grutter versus Bollinger.
right, where they said, well, race can be one of the factors, but not the only factor. And everybody drew a sigh of relief. Well, this is now settled. We know how to draw our admissions policy. I'm not really sure how this case got to the Supreme Court, but it got there, and it's going to have some major repercussions. Explain why we got here.
Well, I think the court, first of all, granted certiorari because the court has changed since 2003 pretty significantly.
Right.
The ideological center has changed. It has moved to the right. And so I think this was an opportunity for the court to be able to relook at what they decided in 2003. I think what was important about this case was Justice Roberts wrote the opinion. And had it been written by another of the conservative justices, I don't think you would have had that carve-out exception that Justice Roberts included in the opinion. And that is, you can consider race as long as you're considering also the experiences of the students, whether it's determination, whether it's courage, but you just can't use race as a plus factor.
Before I begin my diatribe on this is simply the fulfillment of the Republican and conservative agenda that they've talked about for the last 40 years, starting with abortion, et cetera. We'll get there. But how does this boots on the ground? You've been a law professor, but you're now the president of a university that takes federal money, right? Pell Grants. And
We all do.
Absolutely. So it applies to you. Will this change the University of Evansville's admission process?
No, I don't think it changes ours, and I don't think it changes most of them in the country. So there's about 3,100 universities in the country. There are only 68 that accept less than 25% of their applicants. That will have a more dramatic impact on those schools because of the limited number of people that they accept as part of their universities. You add another 9 states that have prohibited using race in the application process. That's about 350 schools. So I think you have a pretty significant impact for 400, 420 schools. For universities like the University of Evansville and most others, we don't use race as a factor in admissions decisions. We use the experiences of students, the holistic approach to their application file, and make a decision. And we accept a lot more than 25% of our applicants.
As you've said, Roberts, who seems to be one of the only ones that cares about preserving the dignity of the court, left a little side door here. Basically said hardship, that a student,
Life
you
experiences,
can't,
I think.
yeah, that you can't consider perhaps the color of someone's skin, but you can certainly consider the fact that I grew up in the barrio, in the ghetto, and I had no parents at home or no support, la, la, la. So, I mean, there is a way, of course, to look at the total student experience.
That's right. I think before it was a race by itself was a plus factor. Now I think race together with experiences allows schools, colleges, universities to create more diversity in their student body.
Powerful dissent, repeating, and I think Justice Jackson has already distinguished herself in a number of ways, basically saying the 14th Amendment, the Reconstruction era, was absolutely recognition of what enslaved people from 1619 forward had put up with. And of course there's a place for considering race, but the numbers are 6-3, and that's the law of the land now, right?
It is, and very interestingly, Justice Thomas read his concurring opinion from the bench that targeted a lot of what the dissent had to say about the 14th Amendment and how far back it went and the impact that it had over the course of the last centuries.
I wonder if he was promised a future trip, if he would do that, maybe on a private yacht or
let's
something.
remove politics from it. This country's changed a lot since the Civil War. It's changed a lot since 2003. There are more opportunities at an early stage in minority children's education to develop those skills and aptitudes that put them under consideration. And that's been a major factor for the opportunities to succeed. Is that a fair statement?
Well, I think that has changed, and certainly the number of students that come from different socioeconomic classes, different geographies has increased over the course of the last 50, 100 years. That I think is true, but I also think the diversity of experiences in our classrooms makes an enormous difference. Whether it's racial diversity or gender diversity or geographic diversity or socioeconomic diversity, the students learn way more from each other than they ever learn from us standing in the front of a classroom.
And Pat and I were young grade school students when our public school system was integrated, a little different situations. But at least I speak for myself, I'm sure Pat feels the same way, I think we gained from going to school with people not just like our next door neighbors, people from other backgrounds. I think it made a better situation. And it was tough implementing, but it worked.
And it's not over. The vestiges of racism are around us. The three white guys probably aren't the people to discuss this, but there's no question in my mind when a former president announces his campaign coming down an escalator saying Mexicans are rapists and criminals, that we still appeal in some times in our politics to those kinds of prejudices.
Well, staying away from politics.
I understand.
We elected the first African-American president not too long ago, and that was a step. We're heading in the right direction.
Absolutely.
And a very meaningful step.
And that's because the previous Republican administration had screwed things up so bad that
There you
the
go.
Democrats were able to carry Indiana, for God's sake. All right, let us move to student loan forgiveness. Here, this same conservative Supreme Court steps into the executive/legislative branch and says, no, you know what? That's a violation of the Constitution, President Biden, for you to try to help students in debt. It was okay when Betsy DeVos did it and declared an emergency under the HEROES Act or whatever, but this is a bridge too far. How will this affect you,
First of
Ian?
all,
What's your thought on that?
In your
decision?
response, please properly state what the court held, if you would, please.
Sure. So this was whether President Biden exceeded his authority
Right.
under the HEROES Act, which was allowed for national emergencies, wars, and military actions for the executive to grant certain powers to the president. In this case, Supreme Court decided 6-3 under the same voting block as the race-conscious affirmative action case. 6-3 to say that President Biden exceeded his authority, that he was only permitted to modify student loan relief, not create a new program. It had a dramatic effect. It's about 44 million Americans, about 16 million of which already applied to the Department of Education for relief. Relief is 10,000 to 20,000 depending on how much family income someone has. Again, 6-3 voting block, and as you described earlier, two major decisions in the last 2 days of the Supreme Court term.
But if you really look at this debt decision, what I thought the court was saying, the majority was saying, yes, administratively, under the HEROES Act, you can modify terms, stretch out the payments, lower the interest rate temporarily. But when you engage in acts that are substantial, eliminating the debt, that power has to be in law. If the power is not there, then the Congress needs to take action.
You're right, that's what the court said.
Right.
It said a $430 billion program needed the assent of the legislature to be able to do that. So Congress has the ability to do it. The court said the president just couldn't do it by himself.
Which, of course, ladies and gentlemen, is part of the Republican long-stated conservative agenda, the Federalist Society approved agenda, and that is to dismantle the regulatory state. They have announced in the last 2 years something called the major question doctrine, where if it's a major question, now we kind of know it when we see it. We got to find in the law where Congress delegated that specific power to the agency to do this, because if they didn't, then we're going to strike it down. They're going to overrule Chevron that said defer to agencies,
here's the problem, Patrick.
and they're going to get to the dismantling of the deep state.
Patrick, you're entitled to your own opinions, not on a set of facts. Bureaucrats are nameless, faceless people that answer to no one.
Kind of like Supreme Court justices.
And they answer to no one. And we did not, in our Constitution, give those nameless, faceless bureaucrats legislative power. If all the Supreme Court is saying, we're going to look at the act, we're going to get the law, we're going to look at the language of the law, the plain meaning of the law, and if the power's not in there, we're not saying you can never do it, but Congress has to create that power. How radical is that?
The Constitution was passed when there was about 30,000 people. We now have 330 million people, and we have to do some governing at the administrative level. You were in one of our departments, the Justice Department.
I was.
And the fact is we have to invest to govern 330 million people, agencies with certain discretion. The Chevron doctrine said we'll defer to the agencies. They're trying to dismantle that. We hear about the deep state. We are got to get to another decision.
Let's move to this Voter Rights Act. Doesn't get a lot of publicity because the liberal media can't get all excited about it, because you had a 5-4 decision. You had the chief, you had Kavanaugh, and all three liberals found that the Alabama's district scheme violated Section 2 of the Voters' Rights Act.
That's right.
And I think that shows when good legal minds get together, they're committed to the rule of law and preserving important acts like the Voter Rights Act.
Well, again, interesting case because Justice Roberts wrote this opinion also.
Right.
So I think, we're going to probably talk about, I think there were 5 cases in this term that were pretty significant.
Right.
4 of which were written by Justice Roberts. This was yet another one. And this was a change in the voting bloc. This was, I think, a surprise to most Supreme Court watchers.
Yeah, especially the lineup of votes. That was incredible.
Justice Kavanaugh and Justice Thomas, along with the 3 justices from the liberal voting bloc, came together with a decision that said that the Alabama voting map was unconstitutional. About 25% or so residents in Alabama are black. They had 1 black voting district. Under the change in the law by the Supreme Court now, they'll have at least 2 voting districts.
And it was
great decision, right, Pat?
I think absolutely. And John Roberts is worried about the Supreme Court's reputation, the Supreme Court's ability to govern when their public opinion polls are now putting them down there with used car salesmen. I think he wrote that opinion. It was clear to everybody how that should come out. The fact that that decision wasn't unanimous is the scariest part of it to me. Alabama, 25% of the citizens are black, and they had them gerrymandered all into one district so that we'll give them 1 congressman, the African Americans, and the rest of them will be white. It should have been obvious to anybody. But was that opinion was 5-4?
That one was
5-4.
5-4. Correct.
So 4 Supreme Court justices said, well, you got to defer to the legislation, and tied to that, and we need to get to the wedding cake. Tied to that decision was, thank God, they also didn't do the judiciary can't review legislative decision making as it comes to voting.
That's North Carolina.
Yes.
Right. That one was 6-3.
And we're scared to death that they could have gone. On that one.
They saw the light. That was a no-brainer as well.
That was a Marbury versus Madison case.
Yes,
exactly. That was something that I thought we decided back in 1803.
Right. But
the first case we all read in law school.
Right.
What's that called? The legislative supremacy or something? There's some clause in the Constitution. Independent legislature. Yeah,
theory.
Rehnquist in a dissent or something kind of gave a little walking to that.
How about
finally, the LGBTQ case? We've justified discrimination against some of our citizens based upon what they use this time, religion or speech?
Well, in this case, it was religion, and it didn't involve baking cakes. involved web design.
Websites, that's
Websites.
right. That's right. The cakes was religion. This time they used speech because
Right.
it was the developing websites.
Because it was creative.
And if you're a business and you got to be open, by golly, if you want to discriminate against gay people, that's okay with this Supreme Court. How do you feel about that one, Pres P?
Well, Justice Gorsuch wrote that opinion.
Yeah.
Right? And, not just in the Marvel movies, you can go from hero to villain. And Justice Gorsuch went from hero to villain. He wrote a case a number of years ago that gave LGBTQ rights in the workplace. And in this one, he sided it with the conservative bloc and decided that, I think the issue here was free speech and religion together was the superseding factor.
Right. Gorsuch, who's become an absolute hero to Native Americans, he writes these opinions protecting American Indian rights.
And he did that again this term.
And he did it again this term. But he writes this one, and you're right, it was the Title VII case, discrimination in employment.
Correct.
His textual reading there was to say it protected sexual preference and orientation. But here, in a case where, and we don't need to get into standing, that's kind of law school stuff, in a case that coulda, maybe, shoulda, woulda, if I opened my business, they gave a business open to the public the right to say, I won't take your business because of my, what, religious convictions?
Religious beliefs, that's right.
And certainly the University of Evansville does not discriminate against people on the basis of their sexual preference.
You are correct.
And so what is your view of this Supreme Court case?
Well, I think this Supreme Court case is one in which Justice Gorsuch, espoused a conservative view, and this again, a 6-3 decision in which the court has moved ideologically to the right. It used to be Justice O'Connor in the center, Justice Kennedy in the center. Right. And now the question is where Justice Roberts allows the court, how far they go to the right. It's been more incremental, I think, this term than it had been over the course of the last term, certainly. What was interesting about this term is that Justice Roberts voted with Justice Kagan more than he voted with Justice Thomas. And Justice Kavanaugh voted with Justice Jackson more than he voted with Justice Thomas.
He writes a lot of concurring opinions, but in my view, ladies and gentlemen, they're simply implementing the Republican agenda. We eliminated abortion, we're protecting private gun ownership, eliminated affirmative action, we've elevated religion, and we are trying to dismantle the deep state.
Can I correct you
and
one
all
thing?
of that has been in Republican platforms going back to Dwight Eisenhower and Ronald Reagan, and life is good if you agree with them.
Well, and any Republican since Dwight Eisenhower is a villain, according to Pat. The reality of it is, and I don't want to get in this abortion thing, did not eliminate abortion. The decision sent it back to the states for each state to make that, and the states are in process of doing that now.
Iowa just this week went to 6 weeks, as I recall, before a woman even knows she's pregnant. A chance to get an abortion has been outlawed in the state of Iowa. It is where we are. Votes matter. We have the most politically, ideologically driven Supreme Court in the history of the United States of America.
Pat, it was no different when the Democrats the presidents had appointed the majority of the court. It's like the pendulum. It just keeps swinging, and it'll swing back towards that middle. It always tries to seek equilibrium. All is not lost.
It sets the argument for term limits for Supreme Court justices. You don't get to vote for them. I don't get to vote for them. Once they're on there for good. It ain't right.
So you want to amend the Constitution?
Well, I don't know that we'd have to amend the Constitution to do a few things as it relates to the court.
Give them terms.
Term limit. I don't. Does the Constitution provide lifetime?
Yeah.
Lifetime appointment.
Yes.
Well, then we need to amend the Constitution.
Okay.
But we
That's
also,
a small task.
I'm not a big court packing guy. I think we could curb their jurisdiction. I think there are a lot of things we could do short of, because we'll never get a constitutional amendment. If we did, we'd abandon the Electoral College. But that's the subject
If you
for
ban Electoral
another
College,
show.
another presidential candidate will never come to Indiana because Indiana won't count.
Pres P, you've been president there at UE for 5 years. Thank you. What a great, you all landed one of the greatest grants to work with our public schools. Great things going on at UE under your leadership. Thank you.
Thank you, Pat.
Thanks for being here.
Thank you, Judge.
When we come back, in a few seconds we have left, I'll try to straighten Pat out. Well, Pat, what a great guest.
Absolutely. President P's got it going on at UE, and a great guest here on the law.
And I hope we can get him back again to talk about this huge grant, this program, Cradle to Career. It's amazing.
It is. He's working with the EVSC. I don't think you embarrassed him or probably insulted him enough. I think he'll come back.
Yeah, okay. How's your golf game? Is it as good as the President's?
No, he beats me like a drum out there on the golf course. He is a fine golfer, hits the ball a long way.
Well, we had a little bad news the last few weeks.
We did. A classmate of ours, Evansville Harrison, want to send the word out to condolences to the Hessman family. Pound for pound, one of the greatest athletes in the history of Evansville and a fine family man. Rest in peace, Fred Hessman.
And with that, we'll see you next month, we hope. Take care.